Hi, my name is Chris Hukins. I'm a professor at George Washington University Law School in the Government Procurement Law program there. We want to welcome you all to this session on state bid protests. This is the first in 4 sessions that we're going to have on state bid protests. We'll be talking about various aspects of practice and theory and potential legal reform involving state bid protests. And we're going to have a session tonight and then a session on Thursday night on the 14th. And then next week, we're going to have sessions on Tuesday night, and the 19th, and we have a session on the last session, which is a mock bid protest. We'll be talking about that some more on the 21st. Thank you all for joining the evening. We actually have registrants from many different countries around the world, registrants from 37 countries and 35 states and territories. Really glad you could all join. For those of our colleagues who've joined us from Africa and from Europe and from Asia, we apologize for the hour. We promise next year we'll do a better job of timing this so it's easier to join. And we are very glad that we could have the 2 sponsors for our program join us. Justin Kaufman is here from the National Association of State Procurement Officials, NASPO, and Tom Kenny is here from the law firm of Kutak Rock. Justin, would you like to say hello?
Sure. Hello, everyone. Justin Kaufman, the Chief Legal Officer for National Association of State Procurement Officials, commonly referred to as NASPO. With me is Megan Smith, our General Counsel, and Faye Tan, who serves as Legal Counsel for NASPO Value Point, our cooperative purchasing arm. Proud and happy to be sponsors as really we continue on our goal of promoting the public procurement profession, and what better way to do so than through series such as these. So Professor Hukins, thank you. And we're very happy to be here.
Excellent, Justin. Tom?
Hi, thank you, Professor. And I would echo Justin's comments. My name is Tom Kenny. I'm a partner at the Kutak Rock law firm based in Omaha with 19 offices around the country. We're very proud and pleased with the opportunity to participate and sponsor this event. We attended last year and found it very informative and engaging, and I hope you all will again this year. Thank you.
Thanks very much, Tom. So I've already gotten a question in the chat, and please, folks, if you have questions, feel free to put them in the chat, and the panelists will be responding to them. I'll be responding to the questions as we go through. We find that the chat is a more interactive way to respond to questions. It works better than the Q&A. You should know that if you send a private question in the chat, then it won't be part of the public record. But if you send a public to everybody, then it does become part of the record. And our panelists may be putting citations there, for instance, for authorities that are useful. One of the questions we got is whether or not the slides from tonight will be available. They're already posted. They're posted on publicprocurementinternational.com. If you just click over to this session, publicprocurementinternational.com, you'll be able to see this session. The slides are already linked there. I posted them on a Google Drive, and I linked through to the Google Drive. If there's a problem with that, just let me know. We're very glad to be able to run this as part of what we do at GW Law. The reason, just so everybody understands, the reason I do on Public Procurement International is I make so many mistakes in setting this up. And if I do it on my private blog, I can correct those mistakes really quickly. So that's why I do everything through Public Procurement International, just so I can make corrections at 2 o'clock in the morning. And just to emphasize, all the statements by the panelists are statements being made in their personal capacity. So as I said, tonight we're going to be talking about the background to bid protests, and we'll be working our way through some very interesting studies that have been done by Zach Jacobson and Dan Cheney. And Missy Copeland then will be talking about her practice in bid protests and state bid protests. On Thursday, we're going to be talking about some of the ways that one can avoid bid protests. We'll be joined by senior lawyers, authors, et cetera, from across the country to talk about ways to avoid bid protests. Then we're going to be talking about, in the third session on next Tuesday, a week from today, we're going to be talking about possible reforms to bid protests. And the final session is going to be a mock bid protest that anybody can join if they'd like to advocate. We only have a limited number of spaces. We only have conceivably either 28 or 32 spaces. So what we're going to do at the end of tonight's session, after we get done talking to Missy, I'm going to take 5 minutes at the end, and I have some poll questions. So anybody who would like to participate in that program, or alternatively would like to get a volume I'll be talking about with you in just a minute, a free volume on state procurement law, please stay after the conclusion. I'm just going to be gathering information from you at that point if you'd like to participate in those events. So we're going to be joined this evening. The panelists are Missy Copeland, Zach Jacobson, and Dan Cheney. And just give you a little background. So Missy went to the College of Charleston, the University of South Carolina. She worked at other law firms, and then she founded in 2003 with John Schmidt. She founded Schmidt and Copeland. So Missy is very active in the public contract law section in the American Bar Association, and she's the editor of the 50-state guide to state procurement law. It's a very important compendium that's used by lawyers all over the country, really all over the world, who might be working with state procurement questions. And I've relied on it repeatedly over the years, and it's a wonderful resource. Missy has also done an extraordinary number of protests across state lines. She's worked in different states around the country, and she'll be talking about, at the end of today's session, she'll be talking about her experience working in different states, how she can work effectively as a lawyer crossing state lines. We talked to her about this in 2019 at the law school, because it really has an important impact on the students. If students know that they're not just going to work in the federal procurement world, or work elsewhere, let's say around the world, but they can work in different states around the United States, that has a really important impact on the career planning. That's why we're so glad that Missy can join us this evening. Dan Cheney is going to be joining us. He has a BA from Brigham Young, a JD from Iowa. He has an LLM from our program. He was a student of ours in our program, and now he's almost gotten his PhD in Nottingham. He's done some really interesting work comparing the European Union's procurement regime to the United States procurement regime. And Dan talked about some of the issues we'll be talking about this evening with us at the University of Nottingham in June at the Global Revolution Conference. The annual conference is held at the University of Nottingham. So we're really, really glad that we could have Dan join us. He actually gave that presentation in Nottingham just before he did his oral defense in his PhD. So it was profiled and encouraged that he was able to go through that. We're also joined by Zach Jacobson. He has a BA from Mount St. Mary's and a JD from Hamlin, and then an LLM. He's still working his LLM with us at GW. He was both an active duty and a civilian lawyer in the Army, and now he's at Seyfarth Shaw, working as an associate there, and he's really done some very interesting work. He's going to be talking about a 50-state survey he did of the various practices in the states along the river. He literally went through all 50 states, and so it's a very important resource. The year before, Ian Hargreaves, who recently graduated from GW, he surveyed 98 countries to analyze their standing rules regarding bid protests, and that was published in the Public Contract Law Journal. So lots of interesting work now being done on bid protests by our students. So today's session, as I said, is going to be an introduction to state bid protests. What I've literally done here is taken a screenshot from the webpage of Public Procurement International. There was some background video. If you watch, we loosely modeled this series on our online courses we teach. I teach 5 online courses. All my courses are online, and the model that we use is we have videos, the background videos, and then we have a video conference with the students, and we have readings. And these sessions are loosely structured on that model. So the background video for this session was actually produced by NASPO. It's a free online training that they offer, and the link is there in Public Procurement International. If you just go to Public Procurement International, you see the link to the NASPO page. For the third session on possible reforms of bid protests, I did a video. I recorded it last week, and I got the draft this morning. I'll be posting it. It's a video talking about the Model Procurement Code and some of the possible reforms to the Model Procurement Code vis-a-vis bid protests. In our second session on Thursday, we're going to be talking about how to avoid bid protests. And Liz Levy and Bob Metzger are going to be talking about that from from a perspective of private sector lawyers who've been dealing with these issues. Lydia Hoover is an experienced lawyer working in the Attorney General's office in Maryland. Her office is in Baltimore. And Lydia will be talking about from the state perspective, and we'll be drawing on some of the conversations we've had in our state and local procurement class. She'll be talking about that. And we're also going to be joined by Bill Curry. Bill just published a book on services procurement at the state and local level. And one of his chapters, chapter 6, is on bid protests. And if you go to the program page of Public Procurement International, you'll see that there's a link there to his chapter 6. And Bill's very kindly shared that with our program. And he's going to be talking about some of the lessons learned on how to deal with bid protests at the state and local level, again, working from his text. And this is what's available on the website. The next session is going to be a discussion about how we can improve bid protests. And we're going to have very, very disparate perspectives on this. Jennifer Dower, who is she's the chair of the public contract law section this year. She's going to be joining us from Sacramento, and she's going to be talking about California's experience with an administrative type process for bid protests. We're also going to be joined by Tom Kenny and by his partner, Ed Fox, to talk about Nebraska. Nebraska, funnily, doesn't have a basic bid protest system, and they're going to be talking about some of the workarounds that have been developed in Nebraska and some possible ways forward for states like Nebraska that are still evolving their bid protest system. We're also going to have Mike Carnahan. Mike Carnahan is one of the 3 newest judges on the Maryland Board of Contract Appeals, and they hear both contract appeals and they hear bid protests. And Mike's going to be talking about his perspective on the Model Procurement Code and really what's worked in Maryland over the years in their system there. The fourth and last session, again, is a session where we'll be asking you, the members of the audience, to join us. And really, you have to do some prep. I drafted and I posted a mock bid protest problem. It's available on the program page. There's a picture of it here on this slide. What you'll do is you'll download the problem. You read it. You should download it in electronic form so you can get the links. It's really based on 2 key questions, which is how the Model Procurement Code approaches protests. And that's laid out in the model regulations that go with the Model Procurement Code. It was last updated in 2000. The regulations are updated in 2002. So it looks a little bit on what are some of the issues. There's some gaps in the Model Procurement Code that are being fixed, but a really big gap in the Model Procurement Code involves organizational conflicts of interest. And this is something that Missy and I have written about over the years in the Procurement Lawyer, which is published by the Public Contract Law section. And it's important because the Model Procurement Code is meant to serve as a template for, among others, state and local entities that are federal grantees. And the federal grants rules now require rules on organizational conflicts of interest, that grantees have in place a process for dealing with organizational conflicts of interest. So this problem is really intended to highlight that gap in the Model Procurement Code. And the way it works in practice is that if you decide to participate as a student, you'll argue as though you were a lawyer, arguing a bid protest. And you'll argue the bid protest from one of the 4 parties' perspective. And I should really stress, you don't have to be a lawyer or be a law student to participate in this. We have master's students who are not law students who regularly participate in our program. They're about 1/3 of our students. They are mid-career contracts folks typically. They do mock bid protests like this and they love it. It's a really nice experience for them to see what it's like to be a lawyer. And it's a really good experience for the lawyers to have a crosstalk. So the law students and lawyers get to speak with the non-lawyers, and both sides get to understand what the other side is doing as they present an oral argument. So it's a very good experience from a management perspective. And I encourage you to stay late in the class today if you're interested in participating. And we're going to have folks from NASPO that I named before participating as judges, Justin Kaufman, Sarah Hildebrand, Bryce Fisk, and Faye Tan. We're also going to have Mike Beavis, who is he's actually going to be working on the Model Procurement Code over the next few years, helping us reform the Model Procurement Code. We're also going to be joined by a current judge on the Maryland board, Larry Price. He's going to be participating and he's going to be offering his perspective as a judge who regularly hears arguments like these. So a useful background text, if you want to buy it, it's available in the ABA bookstore. It's the 50 State Primer. This is the book that Missy's been working on. Missy's really known across the nation for pulling this book together. And there's going to be a third edition of the 50 State Primer published in the fall by the ABA. And at the end of today's class, if you sign up, I'm just going to be taking a poll. If you sign up, if you're a U.S. law student, or you're a member of the National Association of State Procurement Officials, NASPO, you can get a free copy. And that's with the support of CUTAC-ROC and NASPO. So if you want that resource, want to get a free copy of it, we're going to have a sign up at the end of today's class. And again, this is a really good way to do rapid research on state procurement law. Practitioners around the country regularly rely on it. Okay, I just want to give a little background before I hand it over to our speakers. So just want to give a little background on bid protests. So bid protests are called different things. And as I mentioned, we have registrants from countries all over the world. So I want to be very clear that we call them bid protests in the United States. I've lectured on this issue all over the world. No one else calls them bid protests. In fact, in some countries, in authoritarian countries, they don't like the word protest. So we always refer to them as bid challenges. And in Europe, sometimes they're called remedies proceedings. So you're going to see different words used in different places, but they're all fundamentally the same thing. It's a challenge to a decision, and it's a challenge that's brought usually by a bidder, a prospective bidder, or someone that's actually bid but lost. And there's a challenge to a decision by the procuring authority. And the challenge, again, can be to the terms of a solicitation before the proposals are submitted. That's generally the timeline. You'll see that in the mock bid protest problem, by the way. There's some questions about when, in fact, the protest has to be submitted on the Model Procurement Code if it goes to the terms of a solicitation. A challenge can also be brought after award. It can be brought after award, and that process is simpler under the Model Procurement Code. And it's really what people think about most when they think about bid challenges, because that's really where, certainly in the U.S. system, that's where you see the vast majority of heavily litigated bid protests. They have to do with the actual award. Now, the bid challenges can typically be brought in three different places. They can be brought in the procuring agency, they can be brought in an independent agency, or they can be brought in a court. And the procuring agency option is really something that's existed since ancient times, that it was always possible for an angry bidder to say to the contracting official, hey, I worked really hard on this bid, I didn't get the award, something went wrong. And so that's existed for a very, very long time. And in fact, there was a survey done by the OECD that found that if you survey bid challenge systems around the world, that's the most common bid challenge system you see. By the way, just so you know, the UN Convention Against Corruption, which has been joined by almost every single nation around the world, Article 9 of the UN Convention Against Corruption calls for bid challenge systems. So these bid challenge systems aren't something that are sort of made up yesterday and it's a sort of a frolic and detour. These are bone deep in the law all across the world, and different countries are implementing them at different stages. And as we're going to see over the next few sessions, they're being implemented at different rates across the United States as well. So if you go to the other end of the spectrum, the court-based protests, court-based challenges, typically the way the system works is there's an initial challenge at the agency or at an independent agency. And then there can be a court-based challenge after that. Basically, a review what's been gone on either before or what's gone on at the agency. And different systems will set up this different ways. The really interesting work right now is in the independent agency, setting up an independent agency. And from a lawyer's perspective, from a professor's standpoint, the independent agencies are really important because they become a repository of procurement knowledge in a system, and they also help set the trajectory for a system as it evolves. So that's one of the most interesting developments in the procurement world, these developments of these independent agencies. Now, this tripartite approach, this three-part approach, is an approach that was endorsed as well by the United Nations Model Procurement Law. So you have the UNCITRAL Model Procurement Law, you have the Model Procurement Code, all these different model laws out there endorsing a three-part approach. Now, what we're going to be talking about a lot over the next few days is the basic elements of what it is that a bid protest system should include. And this taxonomy here is based upon an article that was done by Dan Gordon. Dan Gordon was the head of the bid protest unit at the Government Accountability Office. He was the acting general counsel at the Government Accountability Office. He was a professor and an associate dean with us at GW. And then during the Obama administration, he was the administrator of the Office of Federal Procurement Policy. So extraordinary background. And by the way, he also wrote one of the key articles on organizational conflicts of interest. That's called out in the mock bid protest, problem. And Dan wrote probably the leading piece on organizational conflicts of interest. He also wrote, very interestingly, a draft revision to the organizational conflict of interest rules. And that draft revision in 2011 was pulled back by the Biden administration last year, but it could very well arise again in ongoing federal reforms regarding organizational conflicts of interest. And that's summarized in a piece by Alan Shavotkin. That's at the bottom of the resources on the program page. Anyway, Dan wrote this really great article that we always jokingly refer to as a sort of a letter to a developing country building its own bid protest system on what are the critical issues. Who has standing? Remember, I told you Ian Hargreaves wrote an article about 98 different countries and the way that they approach standing. Zach will be talking about that in just a few minutes. Where can the protests be heard? Are there 3 different forms going on? What can be protested? The 1994 version of the Model Procurement Law, the United Nations Model Procurement Law, was drafted with very heavy influence from the Canadians. The Canadians did not like bid protests. They did not like bid challenges. So the 1994 version of the UN Model Procurement Law excluded lots of different procurement decisions from possible bid challenges. In the 2011 version, the revised version of the UNCITRAL Model Procurement Law, the U.S. delegation sat in the back of the room and we raised our hand. We said, there's a problem and we really think we should reform this. So the 2011 version of the UNCITRAL Model Procurement Law, partly from pressure from the United States, but also pressure from the Europeans, who by that point had really become very used to bid challenges, was revised. And so that's why the UNCITRAL Model Procurement Law takes such a broad approach. Question about whether or not the contract should be final. This is really an open issue outside the United States. You'll see in the Model Procurement Code, if a contract is formed and then challenged, it can be broken on a termination for convenience. But under principles of Roman law, you can't do that. It's pacta sunt servanda. We can ask Dan to translate that later. The idea is that you have a contract and you can't break it. So then it becomes a race to signature, because the agency will try to sign the contract, so then it becomes in essence not protestable. Washington State recognizes that principle, but they call it something else. They reach that point under a different legal analysis, but it's not unknown. They didn't cite Roman law when they reached that point, but it's a major issue, because if you can't break the contract, if there's a successful protest, there's no point in bringing a protest. And that's really the key, to understand that vendors are bringing bid protests because they want the contract. That's why they're protesting. And if you take away that prize, they'll never protest. And you say, well, that's great. Many contract officials will say, well, that's great. There won't be any bid protest. Not really. That's not good, because this is really a whistleblower system. We're going to be talking about a whistleblower system over these 4 sessions. And we're going to be talking about how that whistleblower system helps and who it helps. But if we kill the whistleblower system by taking away the incentive, by saying the contract can't be undone, that's a very serious policy question. Question is whether the time limits will be for a bid protest. And a related question is how soon how soon does the decision have to be made? The time limits are important, and we'll be talking about that, because the time limits constrain the impact. They limit the impact the protest will have on ongoing procurement. And that's a very important question. Whether or not we stop the procurement, whether or not we stay the procurement, to use a federal term, during the pendency of the protest, very important, because again, remember, the protester wants that contract. And if the protester can't possibly get the contract, because in fact it's begun by somebody else, if the work's already ongoing, the revenues are already flowing, then the protester will say, well, why should I protest in the first place? Because the prize is gone. Other people may say, we're not going to really be talking about the European systems and other international systems as much, but in some systems around the world, you can get damages, very rich damages. But when you talk to most contractors, that's not really what they want. They're protesting about this business opportunity. They're really not in the business of winning damages. So most contractors, as a practical matter, are there about winning the contract, and a good bid protest, in my view, a good bid protest recognizes that and is built around that ultimate prize. Question is how to deal with abusive protests. This is a sort of a marginal issue, but how do you deal with a protester that protests everything again and again and again and again? Now, some people think that incumbents bring protest, if they lose the follow-on contract, they bring a protest just so that their old contract can continue, which we're going to be discussing over the next few days. There are downsides to that. If a contractor brings a non-meritorious or an abusive protest just to extend an old contract, there are reputational issues in a very small marketplace. And these marketplaces, even though the federal marketplace, for example, is over $600 billion, at the end of the day, it still feels like a small marketplace. So there are reputational issues for contractors that try to follow that. The other question is what evidence will be allowed, and really what evidence will be given. What parts of the administrative record will be given to the protester? And we'll be talking about that because that's really important. If the protester doesn't have access to the administrative record, what's the point of bringing in protest? Because he doesn't really understand. All he knows is that he's lost, and he can kind of guess why, but he's not really sure. The interesting thing about the evidence thing, and we're going to be talking about this, is that the evidence issue is really exploding because under principles of open contracting and open data, increasingly we're going to move from what I refer to as the FOIA or open records world, where records are accessible on a request basis, to a world where everything's accessible all the time. And when that happens, this whole question of what access will a protester have to the administrative record, it'll fly out the window. It's not going to be an issue anymore because everybody will have access to the administrative record all the time. Another question is what's the winning percentage? Recently, there was a study done of a Far East nation where they had the winning percentage was like 80%. 80% of protests were succeeding because basically the agencies weren't effectively contesting them. That creates a disaster for a bid protest forum because a bid protest forum loses legitimacy over time. That's what happened with our General Services Board of Contract Appeals. It was eliminated as a bid protest forum in the federal government in 2006 because there was a perception that it was awarding too many protests. The last question is power to enforce. Will the bid protest forum have the power to enforce? The Government Accountability Office, which hears over 2,000 protests every year in the federal government, doesn't have the power to enforce. It's only making recommendations, but it has the power of Congress behind it. If an agency doesn't follow the recommendations, it faces the possible sanctions of the appropriations process. So that's how we resolve that issue. So this is the taxonomy of issues which really, really shape how a bid protest works that Dan did an incredible job in pulling together in his piece. So I'm going to turn it over now to Zach, and Zach Jacob, who's going to talk to you about the study he did on bid protests around the country. Zach, is it okay if I advance the slides? Is that okay?
Yeah, that's great.
Okay.
All right. Good evening, everyone. My name is Zach Jacobson. As said at the top of the hour, I'm an attorney at Seyfarth Shaw in the Government Contracts Practice Group here in Washington, D.C. So why did I choose this topic for my research paper? So a 50-state survey plus the District of Columbia and Puerto Rico was not my initial goal. It's an awful lot of work. I worked during the day, take class at night, wasn't something that I was hoping to do. But at the end of the day, there really was no other way for me to answer the questions that I started asking. So I started coming up from the federal system where you really have one set of rules. I started my approach with, okay, here's what the Model Procurement Code says. And I know we'll talk about that probably later in the series, but the Model Procurement Code, the most recent edition from the year 2000, under Article 9, lays out a sort of general contract disputes process that they would recommend for different procurement systems to adopt. Generally, what this system would allow is that it would be a forum for any kind of contract dispute that arises under a government contract, protests, contract claims, contract claim appeals, suspension and debarment. And I just thought that was interesting because again, having come up in the federal system, there's a different process for each of those things. And it would be unusual to expect, in my mind, to expect to have the same set of people making decisions on that plethora of different issues. So when I began my investigation, I asked, well, what are the states even doing? I know some states have adopted the model procurement code. And then I found out that the states are really all going off in their own direction. And very few states have adopted much of the model procurement code, let alone Article 9. And what was really interesting about that is that it was very hard, because of that, it was very hard to do a rule-to-rule comparison. And so the question that I asked myself is like, how can okay, states are doing things differently. So what framework can I adopt to sort of focus in on a way that I can maybe glean something from all the data that's out there? Next slide, please. So like I said, a rule-to-rule analysis, probably I might have finished the Eastern Seaboard by the time we were doing this presentation, because just going through the procurement codes in the jurisdictions immediately around me would be incredibly complex. And because they're not the same, it would be impossible to really line them up next to each other like you could under, say, common law, and look at the elements of different protest grounds, for example, and see how they're different. You could probably do that a little bit, but that was a non-starter. The taxonomy approach, I think, is really interesting. I was heavily influenced by Dan Gordon's article about bid protests. But again, I was more interested in the why. Why are states setting up their systems the way that they are? And so in order to do that, I had to identify key features and then use those key features as a prism to kind of look at the decisions that are being made by the policymakers who are either purposefully or inadvertently making trade-offs when they're setting up their procurement systems. Next slide, please. So these are the key features I settled on. I didn't settle on these key features because these are all encompassing of every possible mechanism that could exist in a bid protest system. These are just sort of the features that I was attracted to because I saw a version of them play out both in the federal system that I was familiar with, as well as different state systems. And if I remember back to my international class with Professor Eukins, some of the international systems as well. And I thought that this might provide data points that I could use to kind of get my head around what are the states doing. And so an independent tribunal was the natural starting place. How many states have an independent tribunal to hear bid protests? You probably aren't surprised to know, not very many. And so in order to understand why, you had to kind of look at, well, what features do those states adopt? And are those features enough to still make the system effective? Another feature that I was interested in was pre-award bid protests. I know this is kind of a strange one, but I was thinking in terms of sequentially, where are you in the protest process and in the procurement process? So normally in a federal procurement, and under most circumstances, you have an opportunity to file what is called a pre-award protest, or you protest the terms of the procurement before the contract award. You don't have to wait to see who got the contract to come up with a protest. So there's different grounds for that than there would be based on the award. And I thought that that was interesting because that allows the protester to inject itself into the procurement process prior to the award. And it allows an independent tribunal to have a look at what the procurement system is doing. And so just looking at how those two features play together, a system that imposes both an independent tribunal to review protests and gives protesters an opportunity not just to protest a contract that they weren't awarded, but also the ground rules under which that contract is going to be awarded, or the solicitation, the things that they were supposed to include in their proposal. That shows that this system, there is an interest in some level of accountability in the procurement process by outside observers in at least 2 times. And so that tells me that the policymakers in that state do have an interest in accountability, and they're willing to sacrifice efficiency by having a protest occur multiple times in the process. Because for anyone who is familiar with the federal system, these protests can add months onto a procurement, and there's a cost to that. But again, what's the trade-off? Do you want to have a system of accountability at multiple stages in the procurement, or do you want to just have a system of accountability at the very end? If they allow that, and as we'll get to the end, I'll talk about there's a number of states that don't even do that. Now, part of this trade-off between accountability and efficiency is the automatic stay. And this is something that Professor Eukins talked about before. So if you're a contractor, what incentive do you have to open up this accountability mechanism and police the procurement process if the contract's going to be awarded to somebody else? And in many jurisdictions, once the contract has been awarded to somebody else, you lose standing as a contractor to bring any kind of action at all. And that your best case is some sort of taxpayer suit or some sort of complaint to an inspector general or another mechanism that at the end of the day might not even get you any sort of remedy, let alone getting the contract that you wanted. And so the insertion of an automatic stay feature into a bid protest system kind of also reinforces these other features because it gives an incentive to what many of us who studied this will refer to as the private attorney general of the protester to step into the shoes of the government and say, there's something wrong with this, and you need to take a look at it before you can award the contract. Now, of course, there's another side of that is there has to be an incentive, right? Because they're paying for it out of their own pocket. And so seeing those features working together, you begin to say, hey, this is actually a pretty substantial bid protest system in this state because they not only have an independent tribunal and they allow multiple avenues to protest, but they'll stop the whole procurement and have the review process play out. And so that was also a very interesting feature to look at. Now, the filing fee or bonding requirement is actually a little different, and there's different ways you can look at it, and I think it's approached in different ways. Often there'll be a filing fee because the system, the protest system needs to be maintained and you need to raise funds to maintain it. And that's arguably what they do at the GAO. But many would say that, this might also be a way to discourage people from bringing forth protests that lack merit because it's adding additional cost. And so, there's different approaches. What's interesting is that it's not always a fee. Sometimes it's a bond, and then the bond will be a percentage of what the value of the underlying contract is. And so not only do you have to have a grievance and not only do you have to file it in time, but you have to be able to financially put some money behind it, which means you need to be pretty certain that there's something there. And this can be injected at different times in the procurement process. For example, in Utah, this seems to be a much more important step in the appellate process if you lose the initial protest before a protest officer, not in the beginning. But that makes sense because if you look at the system, you get a full panel of people reviewing your protest at the appellate level. But at the initial level, you're just being reviewed by a protest officer. The costs are lower for the state, the time is faster, they don't need to impose this requirement. Now, remedies is something that keeps coming up because those of us that represent companies that are working in this area, of course, they're interested in remedies because, again, why else would they do it? They are for-profit companies. But the remedies also are also distinguishable from jurisdiction to jurisdiction because remedies are not always just getting the contract or not. Some jurisdictions allow you to also recover costs from your bid preparation if you prevail in the protest. Others will even allow you to recover attorney's fees. Which can incentivize more people to bring protests because if they think they're right, the cost of bringing that protest is lower. Now, perhaps, on the other hand, you may not want to offer any remedies at all because you only want someone to bring forward a protest if they're absolutely sure and they're right. And so these are the kinds of trade-offs that are happening whether consciously or not, by these policymakers in different state houses. And then finally, I talked a little bit about appeals and judicial review. What's very common across this country is that the protest is going to be happening at the agency level, the contracting agency. An official, either the contracting officers themselves or their superior, is going to be the one looking at your protest. And I think the reason behind that is obvious. It's probably the most efficient from a cost perspective way to handle protests. But what you lose, perhaps, is a sense of accountability and a sense of a sense of truthfulness if the protester believes the agency is dug in on its position. And rather than looking at something purely from an objective legal perspective, the agency might have an agenda. And so if that's the case, an appeals process or even judicial review is a way to counteract that without having to resort to having a full-fledged independent tribunal. And so I took these features and essentially used them as like my filter. And I just scraped across the jurisdictions, picking up to see which ones existed in which jurisdiction to try to think about, okay, what's happening out there? And in doing so, it was pretty easy for me to group jurisdictions based on how many of these features that they adopted. Jurisdictions that adopted all of these features, I consider to be robust systems. And whether or not this is what the policymakers intended, what they end up with is a system with multiple layers of accountability where procurement actions are subject to review, where protesters are both incentivized to bring forward protests and agencies are incentivized to resolve them quickly. And so agencies are encouraged to follow the rules and procedures, and the protesters are encouraged to bring forth protests if they have grounds and standing. But of course, at the end of the day, the protesters paying for this. They're not, so this concern out there that we're incentivizing people to sue just to sue. I'm sure there's bad actors. I mean, we all have heard of them, but that's not a winning strategy, and that's not the purpose of the system. And so by imposing things like filing fees or bonding requirements, you can discourage that level of behavior. Next slide, please. So I wasn't the first person to do this, and I know I won't be the last, but a really helpful study that I found was a research brief published by NASPO in April of 2013. And this was looking at the state bid protests. So what NASPO did is they surveyed state central procurement offices just to see, what was going on out there and what the opinions of those procurement officials were as to how it was going. And what that survey revealed, and this was a great starting point for research for anyone who's interested in this topic, was that most states do have some form of a bid protest process in place. There's just a lot of variation. For example, many states don't even have the same definition of what a protest is. And a lot of it goes back to looking at those features again. A lot of it goes back to where is the opportunity to protest? And what things are protestable, and then that sort of feeds into the definitions you'll find in their different procurement codes. Next slide, please. So these are the key findings, and again, this was very informative for somebody like me who did not have a lot of experience in this area when I started off on my research. You can see that the majority of officials that were surveyed believe that a protest system does provide a fair process and a real check on flawed or anti-competitive procurements. But what's interesting is that they're thinking about that in 33 different procurement systems. And so when you look at those 33 different procurement systems and none of them are the same, you begin to wonder, well, wait a second, does any of this really matter? And that's, again, reinforcing the key features approach rather than doing a rule-to-rule comparison. You see that of those 33, most of them adopt, most states adopt at least half of the features that I listed above. Many adopt even more. And of course, there is a spectrum of opinion out there. And I think that data like this is really helpful, hopefully also for policymakers, because it gives them an opportunity to think about, is the code working for us? Are we making the right trade-off here by imposing more or less protest rules or restrictions? And also I added on there a bullet because we keep talking about fees and protest bonds. It's interesting, but most states just don't require it. And it's not as common as you would think. And so perhaps, that's something that's not going to trend up, and maybe that maybe the arguments behind why something like that would be effective in either stopping frivolous protests or reducing costs of the system don't have a lot of merit. An interesting area of study. I would look forward to somebody getting some more data on that. Next slide, please. So, well, that's not the entirety of my research paper, but that was the summary at the end. And what I found was tremendous variety across the systems. And there's a few things that I really wanted to highlight but before turning on to the next speaker. So there is definitely a spectrum of systems here. And there are some patterns that are not necessarily related to geography, but I think they're related to the same kinds of choices that policymakers are making. And on the one end, you have about, I would say, seven to 10 jurisdictions that would arguably have what we call a robust protest system, where all of the features that I talked about earlier are present and they are being used. And for better or for worse, nobody seems to be complaining loudly enough about it to change them. A great example of a system like that would be the state of Maryland or Washington, D.C. It has all of those features, but they're still awarding contracts, just like the states of Alabama and Mississippi and Washington. So everybody's awarding contracts, but some states are choosing to go in this different direction. And so what I think would be interesting would be to find out what costs are being incurred on the state by having that in their protest system, and what savings are being recovered on the back end by having more competitive procurement marketplace. Those are the similar kind of studies that can be done at the federal level, because you have such a long, such a wide range of procurements of different types, and you're able to get a lot of data that you can't necessarily get at the state level. Another thing that I thought was very interesting, most jurisdictions did require a stay. I think the number was 32 jurisdictions did require a stay for a timely filed protest. Now, not all of them permitted pre-award protests, but there does seem to be generally a way to incentivize people to bring forth these protests when they believe that there has been an improper procurement or that there has been something illegal happening. Now, you can always go to the courts, right? If I'd have one takeaway from my study, it's that every jurisdiction, if you want to file a protest in your jurisdiction, there's a way to do it. But there are a couple of jurisdictions that you can't rely on your state court, and you have to get really creative to find a way to get around. I know we're going to talk about Nebraska later in the series, and I'm really excited about that, because what people forget, because this system's been around for a long time, is that being able to bring a legal action against the government is really a waiver of sovereign immunity. And so the states are choosing to allow this to happen to them. And so how they allow it to happen, well, we can go through these features and everything, but there are some states that just say, we're not going to play. We're just not going to do this. And if you think something's illegal, you can report it to our attorney general, you can report it to our inspector general, or, good luck, bring it in federal court. Or I guess in the case of Massachusetts, you can go to state court, but you can't go to federal court. Anyway, it was very confusing. I've almost eaten my time just going through the slides. So Professor Eukins, unless you have any questions for me, or if there's any topics you want me to cover, I'm happy to stop talking now before I take away any of Dan's time.
This is really very, very interesting, Zach. Thanks. We're getting questions in through the chat. One question that we got is, does NASPO or do states publish the number of protests filed each year? Zach, were you able to see any information, any data like that?
It depended on the state. Honestly, some states you can just look them up on Westlaw like you can in the federal system. Other states, it's because it's an administrative process between you and the procuring office. You might have to file some sort of state level Freedom of Information Act request to get that information.
Yeah, very good. Okay, and what I thought was really interesting about your presentation, Jack, is that we're doing a parallel study at the federal level it's a Defense Department study on how to improve the bid protest system. And what's really coming out in that study is that there are two basic reasons to have a bid protest system. The reason that you identified, which is to use as a management tool to identify where there are failures in the bidding process, in the procurement process. And the other reason is kind of a dignitary interest. You want to make sure that vendors feel like they're treated fairly for any multitude of reasons, and put those two purposes together. They really explain the various functions you identify. So, for example, the right of a judicial appeal, is that necessary if the whole goal is to identify management issues? Maybe not, but it was really necessary so that contractors feel like they can go to a separate forum, a fair forum, and have their concerns, their liberty or their property interests addressed fairly. So it's interesting to take that different approach and really go, and your analysis really brings out those two purposes in a very, very interesting way.
Well, if I could just to jump on that really quickly, I have to give a shout out to my law school state of Minnesota, because they have kind of an interesting system where you got to go to court unless the contracting officer chooses to put bid protest procedures into the solicitation and into the procurement. And so they've taken a kind of interesting, I would say, administrative rather than confrontational approach, where maybe for this type of procurement, whatever it is that they're buying, they do want to have that level of accountability, and they would rather it be managed administratively than be spending their time in court. But for other things that are more run of the mill, maybe they just don't want to bother with it because they know that the chances are that everything will be above board. So it gives opportunities for states that are acting for the right reasons and making these decisions to have a lot of flexibility when they're playing with what types of opportunities do I want to place out there for the private sector to step in and do some accountability. Because otherwise, if they wanted to have a fully accountable system purely staffed with state officials, every single contract would have to be reviewed by an outside agency. And that's just something that at the federal level, at least, is not possible. I can't imagine how the states would be able to do it too.
Thanks very much, Jack. Why don't we go ahead and take a 5-minute break until 5 minutes before the hour, and then we're going to have Dan pick up from there. Thank you again, Zach.
Thanks.
That was really, really good. I enjoyed his presentation.
Yes, that was really, and I hope Zach can hear us, because the chart he has at the back of his paper is going to become invaluable for protest practitioners around the states. It's really interesting.
Yeah, no kidding. Is he already in the process of publishing that, or?
No, I think, Zach, I hope you can hear us, because we're just about to encourage you to publish.
Yeah, that's fantastic.
It's the first step, I think, in a much bigger paper. And I think that would be the one that'd be publishable. Because this is really, it's like you scratch the surface, because the analysis I did a closer analysis of some states where I actually drew out the features and looked at how the code was structured. And I'd want to do that with all of them, rather than just have a sort of surface level survey. But you probably know better than me about publishing. So I'm certainly happy to take any notes.
Very, very glad to talk with you about that. So we're going to turn over to Dan Cheney to talk about his study. So I should say, I didn't tell the whole story. So the last time he presented on this in Nottingham, not only did he have the pressure of his oral defense coming up in less than an hour, but also I stopped the presentation so we could take bets on whether or not he'd succeed on his oral defense. I'm not going to do that tonight. Dan, I'm going to give you the floor.
Well, thank you very much, Professor Eukens. I know Professor Eukens was very kind and mentioned that I'm in the Air Force, and already gave the disclaimer that I'm just speaking on my own behalf and not on behalf of the Department of the Air Force or any other U.S. government agency. But I like to emphasize that I have been in the Air Force 18 years. I'm 2 years away from retirement, so I like to emphasize I don't want to be fired for anything I say today. So even if you complain to my chain of command, I want it to be very clear that I said up front, I'm just telling you what I think. So next slide, please. So what I'm going to talk about is some research I did. It was actually for my dissertation. It was actually, I'll explain later in more detail, but it was kind of for just one footnote in my dissertation. And I tried really hard not to do this research because I knew it was going to be a heck of a lot of work, and really just one footnote in my 300-page dissertation. But this paper spun off from that research. I had so much extra research to write that footnote that I thought, well, I might as well write a paper with all that extra work I did. But I'm going to talk about why I care, and I'll have to tell you a little bit about my dissertation to do that. Why Europeans may care, because that's what I was presenting last month, as Professor Eukens mentioned. And then I'm going to give you caveats, conditions, trigger warnings, and copious apologies for problems with my methodology. I'm not going to be able to give you as much data as you would like. I have a very narrow question I'm asking, and even that question I'm not able to answer with 100% fidelity or detail. And then to be honest, I don't have a conclusion yet. I don't know if Professor Eukens put my paper up yet. It's just a draft that I presented last month, and I'm still finalizing it. But I'm still thinking through what the ramifications of these data are. I'm still sorting that out. And in fact, if there are comments or questions later, or if you want to hit me up on LinkedIn or whatever, I would love your comments about what you think the ramifications may be. I was intrigued last month by how interested the European audience was with my presentation. I wasn't 100% sure they would even care. I thought they might have been there for the other presenters on the panel. Next slide, please. So kind of off topic, but I'll just say, if you are considering a PhD, I do have 4 words of advice for you. Pick a narrow topic. 7 years ago, I decided to apply to Nottingham to do this part-time PhD program. 8 years ago, I should say, I applied, and it's been 7 years that I've been working on the degree and did my oral defense last month. Absolute worst idea is to take the 2 most complex procurement systems in the world, at least the 2 most complex that I know of, and try to compare them. That was not a simple topic, and so that took me took a lot of time. So that's my word of advice. If you're thinking about a PhD, don't do what I did. So next slide. So this next slide is a bit of an eye chart. I don't expect you to read it, but this was what I was trying to do: a transatlantic comparison between U.S. federal procurement and procurement in the European Union under the procurement directives. And so there's the abstract, and this was a real pain in the neck for the last 7 years. Again, pick a narrow topic. Next slide. So there are a lot of different ways you could try to compare procurement in the US and the EU. What I decided to do, and I started to say this just now, was to try and compare federal, under the Federal Acquisition Regulation, procurement with EU procurement. You could do it, you could compare local to local, you could compare US state with member states in Europe. There are a lot of different permutations, I suppose, about how you could do that. But that's what I chose to do, was try to compare kind of a standard unified, if all the member states were the same, and they're not, I tried to compare just kind of the generic member state with the US federal government. And that's what I was trying to do. So next slide. Yeah, and then so what I try to do is I pretended there's a common code, and I'll mention this in more detail on the next slide, but I pretended that everything in the EU was pretty standardized, and that really is not the case. There are a lot of variations between Italy and France and Germany and so on. They don't all apply these European procurement directives in the same way. I decided, that was the best that could be done. I list some of the problems with the other approaches on the right column, and I decided it's not perfect, and there are some disanalogies, and I spent a lot of my first chapter in my dissertation talking about that, about how comparing these two doesn't quite make sense, but it's maybe the best way that these two systems, these two very different forms of government, could be compared. So next slide. And one more, sorry. I've got animations built in there. So in this slide, what I've done is I've compared on the left the merits, on the right the demerits of the way that I tried to do a comparison. And as you can see, it's not perfect. I really wanted to stick to just the federal level in America, even though I knew that was a problem, because I'm really not talking about more than half of the procurement in America by doing that, by talking only about the federal level. But I knew that there was more literature about the federal level, and I knew there were more data. And I was trying to avoid the state and local stuff, because I knew this was going to be hard to write about for all the reasons Zach just talked about. This is complicated stuff, and there's not as much out there to use to write a dissertation. So I was trying my best not to write about this, but I stumbled into it anyway. Next slide. So
Can I ask a quick question, Dan? Can I ask
yeah,
a-
absolutely.
So one of the things that's really struck us always as Americans is that the European directives, European procurement directives, are informed by this goal of European integration, and that can have a distorting effect on procurement law in the European Union, because the directives, which drive all the European member states, are driven in the first case not by doing good procurement, but rather the first goal is to integrate the European Union. In your review of American, and both at the US and the federal level, at the state level, did you see also a common theme that would set us apart? What makes us different as Americans?
Yeah, I mean, this is a great question. And I talk about that a little bit in the second chapter, kind of some common themes that you can see. And I think one of the most important things is that the EU resembles kind of an international system. So when you talk about them wanting to integrate, that is part of the European project, obviously. And so what they're really concerned about is fair treatment among the member states. We're more like and we are a domestic system. And so what you see in a domestic system is we're more concerned about, if you had to put one label on it, all this is kind of a catch-all, I would say US procurement, whether at the state, and from what little I know about the state and local level, but we really care about best value. I mean, I think that's kind of, they're concerned about fairness, equal treatment, that sort of thing. And you see that in international systems and domestic systems around the world. It's not just the EU and the US, but that's a crude comparison, but I think it's if you had to put a label on it, I think best value is the one that probably is the thing that we care about the most. So, great question. So on the left-hand side, you can see my 6 chapters. I just mentioned something from the recurring themes, chapter 2, but then I had 3 chapters where I just take 3 different types of procedures: qualification and award, competitive procedures, and challenge procedures. So bid protest, that's my chapter 5. And one piece of that chapter, everybody's talking about this book, this article by Dan Gordon. I thought I discovered that. I guess other people have read that too. But I really framed that chapter 5 around Dean Gordon's essay, his article. It was just really helpful to think about the different features that any procurement system must choose. But I guess, yeah, I guess it is on there, litigation levels. So on the right-hand column, so one piece of that chapter, one section was about litigation levels. And one of the most surprising things I found in my research, because I had read in Dean Gordon and Professor Schooner and others, everybody talks about how we do so much litigation in America, that we have, and we're sort of known for that around the world, not only in government contracts, but across the board. And what I found really interesting was the fact that the litigation levels, and I'll talk about this more in a second in more detail, but actually they do a lot more bid protests in Europe than we do here. And so in writing about that, that was, like I said, just one section of one chapter. Next slide. And one more. Yeah, there we go. So yeah, next, here it is. I found that if you compare, and there's an obvious problem here, but if you compare just the federal level in America and procurement under the directives in Europe, which means, this is why you'll see the obvious problem. That means at the national member state level, at the regional level, and at the local or city level, we do about three protests per million of our population, and they do 27. That was the best way I could try to compare apples to apples, was just to look at populations per member state. So this is not the EU as a whole. This is member states and then averaging them out and not weighted by population. But that's like 9 times higher. Like I did not expect that at all, to see that they protested that much more. So I was making a big deal about this. And my supervisors, if you want to click the next button, pointed out that the obvious problem is that I'm excluding the state and local level in America. So how can I say for sure that we still don't do as many protests in Europe? Maybe we do a lot at the state and local level. And I tried every way. I did a real survey of the literature to see if anybody had written about this, and I couldn't find anything. And I said, well, let's just assume that at the state and local level, let's say that at the state level, there's another 3 per million, and at the local level, there's another 3 per million. That's still just 9 per million. So Europe would still be triple the rate of bid protests in America. And they said, no, that's not good enough. And then I contacted, next slide, all the experts. A couple of them are on this panel today. And I said, hey, this is 2 years ago. Has anyone done this? Has anyone surveyed to figure out what the bid protest rate level is at the state level? And they all said no. And I went back to my professors and I said, see, nobody's done this, so I don't have to do it, right? And they said, no, you still have to do it. That's exactly what I was trying to avoid, because I knew this was going to be a lot of work. Anyway, that's how I stumbled into this. I was just trying to answer that one footnote so I could say, yes, I know I'm comparing federal with national, regional, and local. And so it's not a perfect comparison, but I've done the state numbers. I did talk my professors out of doing the local numbers, because I figured out that there were 400,000 local contracting authorities in America. And I said, I don't have time to do 400,000 of these. I barely had time to do 50. Can I stop here? And they said, okay. But that's as far as I made it. But so I have an ulterior motive. I wanted to explain to you why I have this one very narrow question and how I got into this research. I have sort of an ulterior motive. I hope that my dissertation will become a book in a year or so. So I hope I've piqued your interest, because my book will have nothing to do with state and local procurement. It's going to be comparing US and EU procurement. But anyway, I need to pay for my daughter's college. So I kind of hope you'll buy my book when it comes out. But next slide. So why Europeans may care. And this is the pitch I was trying to make last month. I was worried that it might be too parochial or too, for my audience in Europe, that they might be like, who cares about US state procurement? Well, here's what I came up with as I was trying to make this pitch to them and encourage them to take interest in what I was talking about. So next slide. This has been a really big deal in free trade negotiations with Europe, both in 93, 94, when we were talking about US-EU negotiations over the World Trade Organization Government Procurement Agreement, and then again 20 years later over the TTIP negotiations. Europeans were banging their fists on the table saying, hey, when we give you access to our procurement systems, when we grant you coverage so that you're able to sell Americans in Europe, you get access top to bottom, because that's the way the directives work, because the directives apply at all levels. And you know what, America, you're only giving us partial access. You're only giving us 37 states and really spotty coverage at the municipal level. So this has been a big deal for the Europeans. And so that's where I think, to my surprise, last month, people were kind of interested in this, because this is something that bothers them, that we don't have the same degree of coverage at the state level. But next slide, here's more to the point why they would care about bid protests. And that is, there's a lot of talk in Europe about GPA plus and about institutions. And the point is that they want to have not just access, not just coverage, but they want to have meaningful access. And that means having access to forums where they can protest, forums where they have a chance, forums where their concerns, their grievances will be heard. So that's why I think this matters, because I think, and this is just one data point really to know how common bid protests are, but it does tell them something about how much confidence they can have about bid protests at the state level in America. And that's why I think it matters to them, and that's why there was some interest and a lively discussion after my presentation. Next slide. As if there haven't been enough detours already in my little presentation, I just have to mention this. I really fell in love with Justice Harlan. I listened to his biography. It came out just last year. Just a fantastic book. But he was the lone dissent in Plessy v. Ferguson, and he was just for like 20 years or more, was just on every decision that the Supreme Court got wrong. He was the one voice that dissented. Just a fantastic book. Just such an interesting man. But I found a quote from him, and that's my epigram for the start of my paper, where there's a right, there's a remedy. So I thought that's perfect. And just to tie it in slightly with my presentation, because apart from my epigram, there's no other reason to mention this great book, but he kind of came to the Supreme Court with modest means. Most of the justices at that time were wealthy men, and they were expected to do a lot of entertaining in Washington, which was expensive back then, like it is today. And so to make ends meet, he taught at GW. Taught courses at GW for years and years, I guess night courses. So that was his job on the side, was to be a GW professor. So I thought that was pretty interesting. So next slide, and I'll start talking now just briefly about some of the problems with my methodology, because I know it's not perfect, and I think that'll be obvious. It's not going to tell you everything you want to know about state bid protests, but it does provide some information that I think may be useful to you. Next slide. So I emailed all 50 states, or called, I emailed them first, and the District of Columbia. And what I was trying to figure out was numerator, how many protests are there, and denominator, how many procurements are there? Just so I can come up with a percentage, like what is the percentage of protestable procurements that are actually protested? I asked them for 10 years, but I found that most states didn't have information going back that far. So some states gave me that. I got 10 years for a few, but what I ended up doing is just shrinking it down to 5 years, just so it'd be consistent across the board. So I looked at 2016 to 2020. Sometimes they referred me to publicly available databases, which I preferred, because I like to look at the raw data, and that was helpful. But not every state had that much information. So sometimes it was just an email, and they would just give me the numbers, or they would give me case names or whatever, but it was just an email back and forth. When they didn't answer, I filed a Freedom of Information Act request. Every state has a slightly different name for that, but basically the same idea as at the federal level. So I already mentioned some of the shortcomings. So next slide. I mean, one of the obvious ones is I still don't know anything about the local level, right? The 400,000 local authorities, no idea what's going on at that level. My guess is there's probably even less. There are even fewer protests going on at that level than at the state level, but I don't know for sure. I don't have data for all 50 states. 2 refused to answer, 4 ignored me, and 8 do no collection of information. That leaves 36. So I was able to get 36 states. I don't have it for everybody. And I didn't try to do like weighted, my average rate is not weighted by population. So Wyoming gets the same count as California, right? 581,000 versus 39 million. So, you know, maybe I should think about how to reframe that data when I present it in my paper, when I finalize that. But, and again, protests are just one data point. Another point that I should mention, Alix Towns, we had a good conversation after over dinner. and last month after I made my presentation, and she pointed out she thinks my numbers are too high. She thinks the state protest level, and she has much more experience in this area than I do for sure. I do exactly 0 state protests in the Air Force. That's not my line of work, but she does, and she knows a little more about this. And she's, I think your numbers are high. And we got talking about it, and I think my numbers for my my numerator are a little better than for my denominator. So what that means is it probably bumps up my percentage of bid protests, because I was often able to figure out very specifically how many protests there were, but I'm not sure that I always was able to establish how many procurements there were. Sometimes there were more agencies than I was able to get my arms around. Not every state was very helpful with that. So they might tell me, you know, the example that Alix used was, they might have told me what the number of procurements by the state equivalent of the GSA would be, kind of a centralized procurement body, but there might have been a lot of other decentralized state procurement agencies that I didn't get. So sometimes I think my numbers are a little high, is what I suspect. And I think Alix is right about that. So next slide. So I already mentioned that 2 states, findings, here we go. Next slide. No, one more. Findings, next one. Yeah, so I mentioned 2 states refused to answer, and I was really upset the first time they refused to answer, and they just said, no, we have those numbers, but you can't have them. After I filed my Freedom of Information Act request, I started pounding the table and I said, I'm an American, I have rights. And then I did like 5 minutes of research and I realized, no, I don't. The Supreme Court says I don't. In 2013, I don't have a right as a non-state resident to this kind of information. So next, there's an animation, I think, where it shows the case. Yeah, one more. What about my privileges and immunities? Nope, Supreme Court says I don't have any rights. So I don't have a fundamental right to that stuff. So they were right. And I had a fun talk with a guy in Arkansas who got a good laugh when I told him I found that case. He said, yeah, there are a lot of state officials who were really grateful to the Supreme Court for that decision. So next slide. There were 4 states that are sort of ignored me or still answering me. I don't know, somewhere in between there. They've given me partial information and they've told me they'll get back to me. I started this over a year ago. So mostly they're just ignoring me. And you see I've broken out the ones with the asterisks are the ones that are GPA signatories. So it's kind of interesting. These are the ones that have committed to work with other members of the government procurement agreement, other signatories. I thought it was kind of interesting to break out which ones were cooperative and which ones weren't. So next slide, partial answers, but not enough to really put into my data. Illinois. What I found is there was a chief procurement officer in Illinois. There were 4 different ones, like one for highways, one for education. I can't remember what the other 2 were. Maybe Zach could help me. But there were like 4 of them and only one of them answered me. So, you know, yeah, I have numbers for like 1/4 of the centralized, but I didn't feel like I had enough data to really include that in my results. So I got some information from these states, but not everything, not enough. Next slide. And then 8 states just said, some of them were very responsive, and some of them answered me within just a day or 2 of my email and said, yeah, we don't have any of that. We don't do any collection of data. I thought that was very interesting. One of them I mentioned last month, I just think this is a funny story, but I had a friend leave the Air Force and take a job with a state agency. And his first job when he arrived at the state agency was to answer my FOIA request at his new job in one of these state procurement agencies. I just thought that was hilarious, such a small world. And the next slide, I was able to get from the non-GPA signatories. So there are 13 that have not signed on to the GPA. 6 of those answered me and gave me enough information that I could include in my final results. And the next slide, of the GPA signatories, 25 of 37 gave me enough that I could at least come up with some numbers. So next slide, I'm just about out of time, so I'll give you my results and I'll stop talking. Average protests per million. So what I found is at the state level, the 31 states I came up with were 5.2 was the average. And that's an average of GPA and non-GPA. So non-GPA 9.9, and I'll mention why in a second. That's such a small number that I think it's kind of the tyranny of small numbers. So I think that number is a little bit off, is my guess. And I'll mention one other. If you want to hit forward, I think it'll show an animation. I think it has the New Jersey number, because New Jersey I think is way off. So New Jersey is 34, and I think that throws off the non-GPA states. So the federal level is 3. So that means one more animation. And it'll show on the right-hand side kind of how to compare that. So again, Europe, we talked about that before, 27 per million, 8.2 in America, not including the local, but I think my state numbers are too high. I don't think those are, they're estimates. They're the best I could come up with, but I think they're still, I'm guessing, about triple what we are. So I feel vindicated now. What I told my professors before, I think it's about triple the rate of bid protests in Europe. Not including the local protests, city and local. But you can see in some countries in Europe, it's very low, 0.1 in France, which is interesting because France has had a bid protest system for a long time. Some countries in Europe, they're much newer, and yet they have a lot of protests. Sweden is the highest with 272. So they're doing what, 90 times, I guess, or if you take the 27 times, if you take the state plus the federal level. So a lot of protests there. Next slide. And so protest rates of the GPA states, 1.68% are protesting. Of the non-GPA, 10.28%. Again, I think New Jersey is throwing that way off, and I'm going to have to go back and look at those numbers again and try to figure out what went wrong, because I don't think there's any way that the protest rate was 50% in New Jersey. The total rate at the state level was 3.35. Click one more, and it'll show the federal numbers at the bottom of the screen, just to compare. So that's actually higher than this federal level. But again, I think Alex is right. I think my state numbers are probably a little bit off, and so I'm, if anything, a little bit high. And I'm overestimating the number of protests, the protest rate at the state level. And I don't know. They have, not that I know, that I'm aware of. No numbers have been calculated for Europe to try and figure out the protest rate over there, to make comparisons in that way. So as I said, I have not figured out exactly what my conclusions are from this data, but I have the data, and look forward to any questions you may have. Thank you.
Thanks very much, Jan. It's really fascinating stuff. Just to note that the statistics from Sweden that you came up with are the really high number of protests per million people. When Dan presented this in Nottingham, we asked a question of the Swedish professor there, who's been working in the system for a very long time, Andrea Sundstrand. We said, Andrea, are the protest levels in Sweden so much higher? Because in Sweden, you can buy protest insurance as a vendor. You can have, it's a form of business insurance that will cover you if you have to bring a bid protest if you lose. We said, is that insurance, the availability of that insurance, which is an interesting option down the road in the US market, is the insurance driving protests? And she said, no, this is just a very effective system. People are used to being able to challenge errors, and they bring those challenges. Dan? We had a couple.
And I asked Andrea about that also, and she mentioned to me that the other thing was Sweden allows protests below the threshold required by the European Union. And I don't remember that number off the top of my head, but the directives only start to cover at a certain number of euros. And Sweden allows it, if it's a procurement for €5, you can protest that. So a lot of the protests in Sweden are over very, very small dollar amounts, is what she told me, which I thought was interesting.
Yeah, that was, so you had a couple of questions in the chat I wanted to ask.
Oh, okay.
So were you able to parse that? You got a question whether or not the research took into account the thresholds. Were you able to parse it that way, or was the data across the system?
No, across the system, I was not looking at thresholds. Great question.
And you got a general question from Jason Potter, which I think you've answered. Which do you have any clear idea why there's so much higher? There's such a so much higher rate of protests in Europe and the EU?
No, really great question. I think partly maybe the novelty. I mean, for a lot of these countries, they didn't really have a bid. I mean, I mentioned France had one, and theirs is very low, 0.1 per million, compared to that, almost 300 per million in Sweden. So there's a wide variety in Europe. But I think for a lot of countries, especially I'd say in Eastern Europe, some of the newer EU countries, I think it's kind of maybe the novelty of it. I don't know. I don't know why that is, but it really surprised me when I found those numbers and saw how they stacked up against America's numbers.
So we had a question, I think Henry Reddick had asked why there's limited access for the Europeans to state and local markets. And I discussed this in the chat. I pointed out that the states have generally been reluctant to join the free trade agreements. Just so the audience understands, because we have a lot of folks from abroad and in the audience, that the United States takes the position that it won't force, it can't or won't force the states to comply with the free trade agreements. The state and local governments are separate from the federal government. That historically was couched as a constitutional argument, less so now. There really isn't, no one's really been able, there have been a number of people who've analyzed that constitutional question and said, look, it would be relatively easy from a constitutional perspective for the federal government to dictate this kind of trade issue, this national trade issue to the states, that they have to open up their markets. But there's a practical problem because of the diversity of rules that Zach pointed out in his paper and the diversity of results that Dan was identifying in his research. There's so much diversity at the state and local level. If the federal government suddenly said, you have to open up your markets, and a necessary part of that would be you have to open up your markets and meet certain requirements regarding non-tariff barriers to trade. Your rules would have to be of a certain type. If the federal government tried to force that tomorrow, based on a trade agreement, there would be chaos across the United States. Dan, did you want to speak to that?
No, I think that's a great point, though. I'm of two minds about this because Zach is, of course, right. There is a lot of variety, but I was actually just going back and rewriting a couple of footnotes because I had a great I had a great conversation with Jim Nagel about the fact that the model procurement code is kind of based on the FAR, and more than half of the states are using some version of the model procurement code. And so what he pointed out to me, reading an earlier draft of my dissertation from a year or so ago, was there's a lot of similarity at the state level. So I don't know, I have kind of two minds about this. I'm trying to decide where I come down on this, but yes, there is a lot of variety when you dig into the details, that's for sure. But there is some broad similarity as well, because his point was, Jim Nagel's point was, why reinvent the wheel? I mean, the federal government has put together this very elaborate code, and so that's what a lot of states have done, whether they admit it or not. They along broad outlines, at least, they followed the FAR, and I think that's kind of interesting.
We got an interesting question here, Dan. Do you think there's a relationship between procurement knowledge and the rate of protests? Is there an ideal percentage of protests to strive for?
No, but we got into a big debate about that last month, about what the right number is. And I would say, and here's where I get myself into trouble in the federal government, I don't think that it's the sustained rate, the successful protest rate at the federal level suggests that that there are not a lot of frivolous protests being filed in the Department of Defense and the federal government. And so I don't know at the state level, how that translates, because I don't have numbers like that to show how often these protests are sustained. I don't have that level of detail. But at least in the federal government, as much as you might hear people in the Department of Defense complain about how this is so disruptive to everything that we do, yeah, it may be disruptive, but I think it may be disruptive in a good way, because if we're not following our own rules and we're being overturned, if I remember from the RAND study a couple of years ago, I want to say it was like 40% is the number that they threw out, and maybe you can help me with this, but are either sustained or the agency takes corrective action. And that's a really high number. That's a really high number. So that tells me at the federal level, at least, it's around 1% or a little less. That's not too much, apparently. And so that the level of protest at the federal level doesn't worry me. And so I guess I'm not too worried at the state level that there are too many either.
And to Ken's question about the high numbers. So as Dan was referring to, he gave his presentation in Nottingham alongside Rob Anderson, who's who was previously the WTO official in charge of the government procurement agreement. And since his retirement, Rob has been working on a study with the European Commission funded study of this Far Eastern nation that it can't yet be disclosed, but in this Far Eastern nation, the protest rates are reaching up towards 80%, really, and it's driven by a very high win rate. And to answer Ken's question, why is there such a high win rate? Is it due to lack of procurement knowledge? No, it appears to be because the agencies are not offering a structured defense in the bid protest, so that the bid challenge goes right up to the decision-making board without having a really cogent response from the agencies. That seems to be the key problem. So to answer Ken's point, when you have very high, and by the way, that creates an upward spiral. More and more, once you have lots of wins, more and more vendors bring bid challenges, and an ugly upward spiral. And so when you see those levels, the number of procurements being protested and the number of wins that really can have structural or systemic explanations that have nothing to do with capacity, but instead have to do with how the processes are working.
Oh, and I saw a question just pop up in the chat. I'm sorry if I'm taking this out of order, but this is an easy one. I was asking if I was going to publish this. Yes, I hope so. I was talking to Luke Butler, one of the editors at the Public Procurement Law Review, and they've expressed some interest. I'm going to revise the paper some more. So I do plan to publish all of this. They get a right of first refusal since I presented the paper at Nottingham last month. And so I assume that's where it's going to end up.
Excellent, Dan. Zach, did you have something before we turn over to Missy?
I just had a question, something that I always wondered about this, and I don't know if you have the data. So I know that the way that the Europeans do source selection is generally a little different than the United States, because there's still an emphasis on a sealed bidding like system versus a complex negotiated procurement. Maybe I'm wrong, but that's at least the impression that I have, that even though they're moving in that direction, they're still haven't moved the way as the federal government. And I'm wondering if you see a correlation between protests rising and the transition into negotiated procurement versus a sealed bidding system.
Fantastic question. I think that observation is generally right. I mean, I think there's still a reluctance to do negotiated procurements in Europe, even though the directives certainly allow for that now. The authority is there to do negotiated procurements, but they still prefer what we would call sealed bidding generally. But I have no idea on the correlation there. That's really interesting. I hadn't even thought about that. Very, very interesting question.
So
at least in terms of how do you do a pre-award protest, right? I mean, there's only certain types of, it's very limited. I was just wondering about that. Sorry.
I don't think I have enough granularity of detail about whether they're pre-award or post-award protests and some things like that to be able to run those numbers, to be able to say if there's any correlation there. But that's a very interesting question. I just don't think that anybody studied it. I don't think the data right now would be easy to come by to figure that out.
What Dan and Zach are talking about is in the federal system, about 60% of the procurements are done using what's known internationally as competitive dialogue or competitive procedure with negotiation, the European directives. That's what we call competitive negotiations under FAR Part 15. And so that's roughly 60% if you look at it globally. In the European Union, the European Commission publishes statistics on cross-border procurements, and they publish it again and again and again. They regularly republish that data, and the European Commission data shows, Zach, to your point, that competitive dialogue, which is like our FAR Part 15, that's only like 2 to 3% of the above threshold procurements going on in the European Union. So it's a tiny percentage. It's possible that's driving the higher level of challenges, but probably not, because it's still so marginal. Like in many American states, the use of competitive negotiations, the use of multilateral competitive negotiations is still very rare in the European Union. So Missy, we're gonna turn now to your section. And I have to say, when we talked about this in 2019, I felt like you opened all these windows, because I just didn't understand the nature of your practice and the incredible things you've been able to do. And I think it's really important for our students. So many of our students say, well, I love Washington, D.C., but I really want to go home and I want to go back to my hometown. Can I go back to my hometown and be a procurement lawyer? And basically, Missy, you answered that question. Yes, you can,
Yes.
because it's possible to do a state level procurement practice actually all over the country. So if you could talk a little bit how you came to work in state level bid protests.
Yeah, absolutely. So I feel bad that Dan and Zach did a lot of work, and I just get to kind of tell stories and talk about myself. So I appreciate the work you guys did. So I started out in a big kind of regional law firm and just started doing administrative law, worked with a partner that was doing bid protest work. And at the same time, there was a partner in the firm who became president of the American Bar Association, but he was not at the time, he was just a member. And he said, you need to pick a section of the ABA and get involved. And at that point, everybody was going to the litigation section, right? And it was huge and you couldn't kind of make your way in it. Well, I'd done a little bit of bid protest work, so I picked the public contract law section and got heavily involved in it. But then we just had a client, my firm's in South Carolina, and I had a client come for a bid protest case in South Carolina. And he said, you know what, you now know our business. Will you represent us in these other states? And actually, we did that in a few states. And with him, we went and did a presentation to his board to show how cost effective it was to use us in different states rather than a different firm in each state. So that is my practice today, is I do state and local procurement work nationwide. And I do bid protests, but I also do help vendors when bids come out, help them do the Q&A. I'm going to pre-bid conferences with them. I help with the contract. I help with contract disputes. And that's probably right now, 80% of my work is doing state and local procurement work.
It's a cultural matter, Missy. So I'm somebody who actually had to get a taxi cab in New York City several times in my lifetime. And that's encouraged a certain personality type in me. As you're doing cross-border work, doing work nationwide, what would you counsel students in terms of, should you have a Yukons personality or should you have a Copeland personality?
And I will tell you, when we talked about this before in 2019, I thought about, has there been an issue doing this? You know, I'm from South Carolina. Obviously, you can tell I got a Southern accent. Have I had trouble with this anywhere? And I really haven't. Every place we've gone, the people have been very welcoming. They don't treat you like you're not from around here, don't come messing around here. We don't get treated like that. We get welcome. We always find that the jurisdictions are really just trying to find, is there a problem here in this procurement and can we fix it? And it doesn't really matter where you're from when you're coming in to do that. The thing I talked about, what the easy part of my practice is, there are principles of state procurement that are just the same all across. Responsiveness, responsibility, full and open competition. Those things are just black letter law everywhere. You kind of know that. Where you get into the differences, and I know this is what Zach found in his, is the procedural requirements. That's what's different everywhere. And when I started, which was over 26 years ago, we actually had a big filing cabinet with paper copies of all the procurement codes and regulations. We had a paralegal that would call up and get it, because you couldn't just go to the internet and get it. And so that was the hard part. That was, and now that barrier's gone because it's all on the internet, and you can get our book, the 50 State Guide, which is where I do always go start. When I get in a bid protest in the state, I think I may know the deadline, but I go to that book, see what it says, and then I go to the internet to make sure there haven't been any changes. But I think that is now, I started to have that kind of multi-state practice. It's much easier now. And so I think that was a long answer to your question. Cultural differences hadn't been a problem. The problem is the procedural requirements. And now that the barriers in figuring those out have kind of gone away, it makes it easier to have this kind of practice.
How do you deal with the fact that you're barred in South Carolina? Are you barred anywhere else?
Yeah, in North Carolina. So we will use local counsel when we need them. because my law partner is also barred in 3 other states. So when we need them, we use local counsel. And we learned as part of that process with that first client, the first other state we went to, he hired us, he hired a local counsel, and then the bill was enormous because we were both doing things. Nobody was managing. So from then on, we were lead, we hired and managed local counsel. And local counsel we need for 2 things: to make sure we're not doing unauthorized practice of law, and to let us know, is there some political thing going on with this procurement? Does the governor have some initiative that this has to be done by this day? Something that's not obvious from the documents themselves. So that's kind of where we use local counsel to make sure we don't run afoul of bar issues. And then also if there's a political issue that's going to affect this, if there's some timing, if this is a hot button issue in the state that we need to know about, that's where our local counsel comes in.
So Zach talked about the fact that the bid protest rules vary so much from state to state. Do you, when you're discussing a potential bid challenge or bid protest with a client, do you talk about the risk that an immature bid protest system might bring to your effort?
Yeah, so I mean, it's a big difference. And I think somebody just posted a question too about the average legal cost to file a protest. So I want to answer that, because that varies so much. For example, the state of Florida, if you bring a bid protest case, it goes to an administrative law judge. You have to go from filing to hearing in 30 days. You get depositions, you get discovery, and those can run $100,000 because you're working a solid month and you're doing discovery, depositions, and everything. In other states, it's a matter of just filing a paper. You don't even get a hearing. So, I mean, that could be $5,000. And so that's something they always have to take into account is this cost really worth it? And it depends on the jurisdiction. And then also the issue of a stay is something that you mentioned is important. Places that have an automatic stay, of course, that goes right into the factor, because if they know they're going to be able to stop it, obviously they're going to have more of a chance to proceed there than in other jurisdictions.
In terms of tracking all these procedural requirements, are you taking the lead on that, or do you rely on local counsel for that?
So I take the lead, but then I always confirm it with local counsel. So I first think I know, because I've been in most jurisdictions with the bid protest. I think I know. I confirm it from the 50 state guide. I confirm it from the internet. And then if they're going to proceed and I engage local counsel, I just say, check behind me on these deadlines, because a lot of them are short. And I know we talked about this before, but I think Florida is probably still the shortest. You have to file your notice of protest within 72 hours. So you're talking quick. I mean, this is the fastest statute of limitations anywhere is in this practice. And that's what makes it fun and exciting too, because in a normal, if you're just doing plain litigation, you got a 3-year statute of limitations, you file a case, it's going to sit for a year, maybe 2. It'll ramp up and do a little bit of stuff, then it'll sit longer, and then you'll get to trial. I mean, it's years. Bid protest work, I mean, it's done typically in a month. So it's a fast paced, it's fun and exciting. You're in different places all the time. You're dealing with different products, different purchases. It's just a fun and exciting practice.
One of the things that surprised me most, missing we talked about since 2018. So just by comparison, in the federal system, it's an over $600 billion system. So it's really almost impossible for a practitioner to keep track of what's going on, the politics, the appropriations, all that. You're essentially at the end of the process, you're presented with a protest, but you don't really track any given procurements. Where at the state level, sometimes you hear about senior procurement lawyers tracking the major procurements in a state all the way through the appropriations process, all the way through. How does politics play into your practice?
Yeah, absolutely. And there'll be, it's interesting because we have kind of people in our network all around, and especially in South Carolina, and they'll say, hey, you want to know this got in the appropriations bill, so this procurement's going to be coming out. So that is where your network comes into play. And of course, vendors will have lobbyists that are tracking that as well. And they'll usually have that person separate from us tracking things until it gets to the point of a bid protest. But we also have our a network of people that let us know kind of what's going on politically, what's happening in different procurements. And it is interesting to track those things all the way through, that you know what's coming and you get to see from start to the end what's happening.
At the federal level, it's almost impossible to divine a political solution for any given bid protest, because the politicians are walled off from the system. There's reluctance to allow them to be involved in the system. It's very, very difficult to come up with a political solution. Even political solution that might include, for example, an outreach to senior program officials. Very, very difficult to do that. You're really stuck in a legal corridor. Do you find it's possible at the state or local level to look for political solutions?
Not usually. No, you're usually, once you're in that process, you're in it. Now, we have seen a lot more, it's not a political solution, but we've seen a lot more of a kind of a mediated resolution to protest. So for example, split the work. Let's see if we can resolve it by you splitting the work with the protester, or let's see if we can resolve it by using them as a subcontractor on something. So we've seen more of mediated resolutions, but still separate and apart from the political side of it.
So we talked about the cultural differences before, but so what are some of the recurring difficult issues that you see in state procurement law? What are some of the things that you see that are most difficult and actually might be possible focus points for the reform of the model procurement code?
Yeah, I know we talked about organizational conflict of interest, and that was and still is huge. South Carolina has actually adopted something since we wrote the articles and since the case that I talked about before. But and there are other places that have it, but it's still so varied, and it's still so hard for vendors to know what the rules are from place to place when they're that different. So I'm really excited about the fact that the model procurement code is going through a revision and these things can be taken care of. Cooperative purchasing is another thing that's huge. And the rules about that are varied. Can you only buy from states? Can you buy from nonprofits? And there needs to be some kind of consensus. And I think cooperative procurements have come a long way, but still, I don't think they're being used as much as they could be used. And I understand there are some states that are saying, we're never going to change. We're only going to buy from states because only states have these certain restrictions in place that nonprofit cooperatives don't have. So that's going to be an issue, but that still is one that I see that's big. Interestingly, I don't know that this is a difficult issue in state procurement laws, but the issue that we're seeing more now, there are two issues that I think are still maybe coming out of the pandemic that are kind of the protest issues now. One, we're seeing a lot more protest on responsibility. Responsibility to me is a really hard issue to be successful in a protest, because you're basically, as long as it's a decent competitor, a good company, it's hard to say they don't have the ability to perform this contract. But because of supply chain issues and everything else that's going on in the pandemic, we've seen those be successful. The resolution is usually not to find the vendor non-responsible, is usually that the agency will just cancel the solicitation. I think they realize the problem of a non-responsibility determination on a vendor, follows them everywhere, something they're going to have to report everywhere. But we've seen, I've had 3 protests on responsibility in the last 3 months. And I bet before that, maybe 1 or 2. So I think, but because of supply chain issues, those are coming up. The other thing we're seeing a lot is, and this is an area that the federal government has addressed that the states haven't so well, is late bids from electronic delivery. The FARs have dealt with it within the government control. They have some exceptions to that. States say you're late, but states are requiring email bids or limited delivery. Companies are not back traveling as much, so they're relying on FedEx and places like that. And then you're relying on some employee of the state to make sure that the bid gets to the bid package room. And so I think there is a place for state law to be more developed in how to deal with bidding and making sure once it's in the government's control, the government has to take some responsibility for that. Because if they're requiring bidders to only submit it to this email address, but then they have some size limit they're not alerting bidders to, so there's room there for that to be fixed a little bit. And those are the kind of the big issues that I'm seeing now that I think are coming out of the pandemic that weren't there before, that are maybe right to be fixed a little bit. I still think organizational conflict of interest is just a huge one that I'm excited about that being fixed in the model procurement code, as well as cooperative procurement.
So just to translate that for our international audience, the organizational conflicts of interest is an American term, but it's a concept that appears around the world. For instance, most trade agreements say that if a vendor works on writing specifications, that vendor can't then bid on the contract as awarded under those specifications. That's an organizational conflict of interest. And it's something that really got pulled into the UN model procurement law in 2011. And so the UN model procurement law ended up looking very much like the Federal Acquisition Regulation. And it's important part because it's part of our mock bid protest. So the concept of organizational conflicts of interest appears all over the world, but it's really rapidly maturing. It's rapidly maturing at the state and local level as well here, as Missy was talking about. And it's also changing at the federal level. That the article that's included in the resources by Alan Shavatkin talks about pending legislation that would fundamentally change the organizational conflict of interest rules in a way that there was a decision in 1984 when the Federal Acquisition Regulation came together, not to require contractors to say, oh, we have no conflicts of interest as an organization. And there's some talk about changing that to really put the onus on the contractors to say that up front. Missy's reference to responsibility, that's the American word for qualification. That's qualification internationally. And a really interesting, Missy, a really interesting question that we're talking about a lot in our international forums, like on Friday, when we talk to Latin American officials about how to exchange qualification information, including debarment information. How do we trade, how we share qualification information using e-procurement systems? It's a really interesting question right now. And I think that it goes back to your point about how there's more and more concern about how do we really assess qualification. There are essentially more and more qualification challenges.
Yeah.
Because I think, Missy, it may be due to the fact that contracting officials have more and more qualification information to work from. The dividing line, this is something that we have to be frank about as Americans when we're dealing internationally. The dividing line between qualification and past performance is really hard to draw. And they kind of mush together.
Yep.
And when you can get a lot of past performance information pulled into a qualification decision, then the question becomes, well, will the contracting officer do a good job? At the federal level, the paradigm historically was Google search. They would Google search the name of the company and say, oh, are there any problems? And now there's so many databases, and there's such a shift in thinking about, hey, should the contracting official really be relying on, we're doing a study right now about whether or not contracting officers or debarring officials should take into account the violations of US labor law. We're doing a study on that for Congress. And that kind of question, do we start drawing in on databases internationally, or do we start drawing in on foreign countries' databases? These are really big questions, and they help explain, I think, Missy, why you're seeing more and more of these cases. I just want to close out here with a question for you, and really, I'm going to ask you to take off your protest hat and put your editor's hat on. Do you think that there's more and more convergence based on your work across so many states and working as an editor? Do you see more and more convergence of laws, state laws around the country?
Yeah, I think so. And I think there's more interest in that now. And I think that, I remember years back, people didn't even know that there was a model procurement code. And it's been around a long time and people didn't even know it was there. And so I think kind of the word's getting around and people are wanting to streamline the process. They're wanting to make it more consistent. And so I think that will happen. And I'm excited for that to happen. I'm not sure that it'll happen in the time that I'm still practicing. So I don't know that I'll get to see that happen, but I do think it makes sense because, right, the principles are there and the different unique timelines and stuff, there's room for that to change. I think everybody wants a clear understanding of conflict of interest, but I think people don't know how to go about doing it. And so having this revision, and I'm excited for the panel next week on the model procurement code, because I think having this revision come out will just revive this topic again. I think people want to do that. I think it's always hard for a government to let complete control go, and there's going to be somebody who wants their own certain language in some legislation, but I think the idea of there being some resource to go to say, this is a tested method of doing this, let's adopt this. I think there's some interest in that.
Thank you so much, Mrs. Well, with that, I'm going to go ahead and reserve the last 5 minutes for class, so to talk with folks who want to take part in the mock bid protest. And if folks could hang on, I have a couple poll questions for them. In the meantime, I want to thank you guys. You did a wonderful, wonderful job. We'll do our virtual clapping for you. Thank you so much. And I really appreciate it. You really advanced our discussion. I'm very, very grateful. Thanks again. So in our next session, we're going to have a discussion of how to avoid bid protests. We talked about this before. I think it's be a very interesting discussion, both from the private perspective and from the government perspective on how to avoid bid protests. And the recording from this evening is going to be available through the program page and also through the YouTube page sponsored by GW, the GW Law School's Government Procurement Law program. So these are, let me see if I can launch these polls. I have 3 questions for the group. Yes, and some very nice comments are coming in the chat. You guys have well-deserved nice comments. So I'm going to go ahead and launch these. There's 3 questions. The first one, if you're a U.S. law student, do you want to receive a copy of the ABA 50 State Guide, the 3rd edition, when it is published? And so, all I'm going to do is gather this information. Then I have the background information through visual registration. So you can just say yes if you fit in that category. The second one is, if you're a NASPO member, do you want to receive a copy of the ABA 50 State Guide when it's published? So one is about if you're a law student, a U.S. law student. The second one, if you're a NASPO member. And the third one is, do you want to present as an advocate in the mock bid protest in session 4 on July 21st? Taking part in this process is a very healthy thing. It's a good idea. If you're available, we have a limited number of spaces, and it's much less scary than it sounds. So I'm going to go ahead and launch these. And if you guys could go, if the participants could go ahead and answer these questions, that'd be great. And I'll just collect the data afterwards and keep track. So Missy, we're figuring out in the first 2 questions, which folks will get the free copies of your 50 State Guide when it's published in the fall. And then for the 3rd question, it's who will be participating in the argument. And depending on how many folks we have participate, I can reshape the arguments to make them simpler or more complex, depending on how many people want to participate. It's kind of funny when we do this. When we do this exercise, you'd be amused, Missy. We do this exercise with our students in our state and local class. The law students are trained on how fragile the American judiciary is as an institution. So the law students are really trained from the very first day. You really have to treat judges with respect, because the judicial is the most fragile branch. It could collapse if we don't respect it. And the master students don't have any of that training. So they go in there. I've had master students yelling at the judge.
Oh,
You can't do that. You can't do that. They're very fragile. My judge, when I clerked, my judge, he was riding the New York subway, and he would ride the New York subway. He would tuck his feet under his body because he was so afraid that someone would step on his feet, and he would swear and bring shame on the federal judiciary. Because he understood how fragile the federal judiciary is as an institution. It was really it was a very important lesson. Looks like we have all the answers in, and I'm going to head and at the end of our next session, I'm going to talk to the folks who do want to participate. I've got that data now in the poll responses, and I'm really looking forward to working with those folks. And I want to again thank you all for joining us this evening. Thanks, Dan. Thanks, Zach. Thanks, Missy. Thanks to all the participants. Have a good night.
thank you.
Bye-bye.
Thank you. Good night, everyone.
Thanks. Bye-bye.